Hello. I literally just got home from a meeting, so I have not looked at anything that Kathleen has filed yet. So I'm going to pull it up. Whoops, because I know Kathleen has it on her website. So I'm pulling up her website now to start going over what she has there. All right. First, we're going to read the supplemental motion. And you can get this stuff on Kathleen Zellner's website. And also, while I'm reading this stuff, if you ask me questions or whatever, I'm reading. So I won't be answering you, but I see Christy is here, and I don't know if any of the other moderators are here, so they can possibly answer questions. And before I start reading it, the thing that I'm always asked is, who am I? My name is Jax West, and I run Stephen Avery Project, MAM Gossip, Free Brendan, Kent Pellegrini's page, Melissa Kaluzinski. All right, scrolling through that stuff. All right, ready? Here we go. Now comes defendant Stephen A. Avery by and through his current post-conviction attorneys, Kathleen Zellner and Stephen Richards, and hereby respectfully moves this court pursuant to Wisconsin Statute 974.06 and the Wisconsin Court of Appeals order of February 25, 2019, for an order reversing the judgment of his conviction and sentence and ordering a new trial. In support of this supplemental motion, Mr. Avery states as follows. Introduction. In 2007, the state spent an enormous amount of time and effort perpetuating a fraud upon Stephen Avery's, and then in parentheses, Mr. Avery, jury. In order to win Mr. Avery's conviction and exclude everyone else as the perpetrator, the state had to convince the jury that Mr. Avery alone was connected to the crime scene. To establish a crime scene linked only to Mr. Avery, the state created a narrative that Teresa Hallback, Ms. Hallback, was murdered in Mr. Avery's garage and burned in his burn pit. It was essential to the success of the state's narrative that all of Ms. Hallback's remains were located within yards of Mr. Avery's residence. If the crime scene was a quarter of a mile away in the Manitowoc gravel pit, and then in parentheses, gravel pit, then the state's theory would have been refuted that Ms. Hallback never left the Avery property alive on October 31, 2005. If Ms. Hallback's remains were actually in the gravel pit, then the defense would have been able to substantiate and not just speculate about an alternative theory that someone else murdered Ms. Hallback and moved her bones to Mr. Avery's burn pit to frame him. In order to successfully convict Mr. Avery, the state presented a false forensic story to the jury, which claimed that the bones in the gravel pit were not evidence because they were not human, therefore they could not have been Ms. Hallback's. The state's representations to the jury were not uncovered until 2019. The state, by its actions in returning Manitowoc gravel pit bones to the Hallback family in 2011, has implicitly admitted to that the bones were not only human, but that they belonged to Ms. Hallback. This stunning action and admission undermines the state's entire theory at trial that was used to convict Mr. Avery and undermines confidence in the integrity of his verdict. The issue on remand is, did the state violate Youngblood v. Arizona when it returned the human bones to the Hallback family in 2011 without giving notice to Mr. Avery or his counsel in violation of Wisconsin Statute 968.205 and the April 4, 2007 trial court order? The answer is indisputably yes. the state took the unilateral action of commingling the human bones from 3 locations, thereby destroying any possibility that the gravel pit bones could be identified as human and subjected to more sensitive DNA testing to determine their identity. The admissions of the state that Ms. Hallback's bones were in the gravel pit changed the scene of the crime to a location which is contrary to all the representations made to the jury by prosecutor Sweaty Sweat Sweat to obtain Mr. Avery's conviction. In 2007, the state misrepresented to the jury known facts and concealed evidence. In 2011, the state acted in bad faith when it violated Wisconsin and federal law by returning human bones to the Hallback family. In 2018, the state continued its pattern of concealment with the appellate court until it was caught. Mr. Avery is entitled to have his conviction reversed and granted a new trial. Procedural background. On December 17, 2018, Mr. Avery filed a motion to stay, appeal, and remand the cause for new scientific testing. Said motion is attached and incorporated herein as Exhibit 1. We'll go over all the exhibits after we read this completely. Mr. Avery requested to perform newly available DNA testing on the gravel pit bones. The motion was denied by the appellate court on December 28, 2018 as premature, and that's Exhibit 2. On January 24, 2019, Mr. Avery filed a motion to stay, appeal, and remand the cause for proceedings on claims for relief in connection with the state's violation of Wisconsin Statute 968.205 and Youngblood v. Arizona, which is Exhibit 3. On January 29, 2019, the state filed a response in opposition to Avery's third petition to stay the appeal and remand this case to the circuit court, Exhibit 4. On February 1, 2019, current post-conviction counsel filed defendant appellant's reply to the state's response in opposition to Avery's motion to stay the appeal and remand the cause to the circuit court, Exhibit 5. On February 11, 2019, current post-conviction counsel filed a letter with the appellate court attaching additional undisclosed documents, and that's Exhibit 6. On February 13, 2019, current post-conviction counsel filed a second letter with the appellate court attaching further undisclosed documents, Exhibit 7. On February 25, 2019, the appellate court granted Mr. Avery's motion to remand to permit him to pursue a supplemental post-conviction motion, raising claims for relief in connection with the state's violation of Wisconsin Statute 968.205 and Youngblood v. Arizona, and that's Exhibit 8. The appellate court specifically made the following findings. 1. The state's objection does not address the merits of Avery's claimed statutory and constitutional violations, and it has not responded to Avery's supplemental filings alleging the possible destruction of evidentiary items, which, it appears, the parties previously agreed to preserve. 2. Having considered the parties' submissions, we determined that the best course of action is to grant Avery's motion to stay the appeal and to remand under Wisconsin Statute 808.075. Though we are not required to remand, we determine that this procedure strikes an appropriate balance given the specific circumstances of this case. Due to this case's extensive history, there is a benefit to having existing claims developed or litigated while they are relatively fresh, rather than positioning the claims to be procedurally barred in a future proceeding. 3. We desire a ruling on the merits so that all claims to date can be considered in a single appeal. The briefing in this appeal has not commenced. There appears to be some potential overlap between old and new issues, and that's Exhibit 8. Now it goes to factual overview. The state's case. The state's conviction of Mr. Avery was based almost exclusively on forensic evidence. At trial, the state told the jury that all of the incriminating forensic evidence was in close proximity to Mr. Avery's residence. Prosecutor Sweaty Sweat Sweat, in his opening statement, relied upon several computer-generated scene models which allegedly illustrated the location of incriminating forensic evidence and its link to Mr. Avery. Sweaty Sweat Sweat claimed that Ms. Hallback was murdered and mutilated in Mr. Avery's garage and burn pit. Sweaty Sweat Sweat's opening statement. Sweaty Sweat Sweat claimed that the proximity of Mr. Avery's burn pit to his residence was particularly incriminating to him. In his opening statement, Sweaty Sweat Sweat told the jury, quote, "This particular computer-generated animation is important to embrace or for a jury to look at in the case because the burn area is clearly visible. How close it is to Mr. Avery's garage, how close it is to the trailer, how close it is to the other area. What's called the curtilage, that is the area that surrounds Mr. Avery's property, all becomes important." Next quote. "Dr. Eisenberg will identify all of these bone fragments. She'll identify from a female skeleton and from examples that are used all of the different parts of Teresa that were found." Next quote. "And as I mentioned, at least briefly, before other analysis of bone and tissue, other things to point to, if in fact the state even questioned whose bones and whose tissue it is behind Mr. Avery's property." End quote. The state's expert regarding the bones. The state's examination of its forensic anthropologist, Dr. Leslie Eisenberg, about the gravel pit bones focused exclusively on the non-human bones and 3 possible human bones associated with tag number 8675. Despite the fact that the Calumet County ledger sheets referred to multiple human bones in 3 additional piles in the gravel pit, which is Exhibit 9, Prosecutor Thomas Fallon never once questioned Dr. Eisenberg about her worksheet, which described those human bones in the gravel pit, and that is Exhibit 10. Oh, and looking over here at comments, I see that there's trolls that are posting here. So when we can, we'll delete their comments. Don't worry about it. They're stupid. Sorry, but I'm not. Over here is where you guys are posting, and over here is where I am reading. So I'm going to continue reading, and we'll clean up the mess from the guilters when we can. Okay. Dr. Eisenberg was given the following questions by Prosecutor Fallon about the suspected human pelvic bone in the gravel pit. Oh, and in the meantime, anybody that's there, go ahead and do what you got to do against the guilters. Have a field day on them because they're ignorant. All right. Question. And in terms of that suspected bone fragment, can you say to a reasonable degree of scientific certainty that that was human bone? Answer. I cannot. Question. And why is that? Answer. I did not. There is a potential for using microscopes to look, for example, to try and confirm if suspected human bone might actually be human bone or animal bone. But given the condition of the remains, I did not believe that cutting into the bone that they would survive that those kinds of tests. And so I did not perform them. And the us and everything I put in there is what is in this, in the transcription of when Dr. Eisenberg was being questioned on the stand. Prosecutor Fallon chose to emphasize the other non-human bones associated with the pelvic bone while ignoring all of the other human bones in the gravel pit. On redirect examination, excuse me, Dr. Eisenberg testified, quote, question, All right. Now, just so that we're crystal clear on this, the various fragments from the gravel pits southwest of the property, originally you were only able to determine one was clearly non-human. In your subsequent review and analysis, you determined several more were clearly not human. Is that correct? Answer: that's correct. Question: and as a matter of fact, there was only 3 left that you had a reasonable suspicion on that could be human. Is that correct? Answer: that could possibly be human. That is correct. Question: and as a matter of fact, as you sit here today, you cannot tell us that those bones, to a reasonable degree of anthropological or scientific certainty, are human, can you? Answer: I cannot. And just so you all know, I am reading this off of Kathleen Zellner's website, and I am currently on page 11 of 41. So then it goes into Prosecutor Kratz's closing argument. In his closing argument, Sweaty Sweat Sweat emphasized the bones in Mr. Avery's burn pit. Quote: he, Mr. Sturdivant, found the bones, the small bone fragments, intertwined or mixed in with the steel belt from the tires. All right, the bones being intertwined and mixed in is the state's, or one of the state's, strongest argument for this being the primary burn site, unquote. Prosecutor Kratz also focused on the elimination of other burn sites. Quote: Mr. Pevito, as you heard, however, also recalled that the bone fragments were intertwined with the steel belts and, I believe, rendered similar opinions as to the primary burn site. Mr. Pevito also eliminates other burn locations, unquote. Sweaty Sweat Sweat emphasized the number of human bones in Mr. Avery's burn pit. Quote: what she also tells you is that every bone, at least a part of every major bone group, has been recovered from the burn area, from that which is behind Stephen Avery's garage, unquote. Sweaty Sweat Sweat told the jury the events at these 2 locations, Mr. Avery's garage and burn pit, told the whole story, and only one person committed this crime. In his closing argument, Trial Defense Counsel Jerome Buting stressed the importance of the bones found in the gravel pit when he said, quote, if that body was burned somewhere and then moved and dumped on Mr. Avery's burn pit, then Stephen Avery is not guilty, plain and simple. Now that is why the state has gone to such trouble avoiding the fact that the bones were moved. That's why you heard nothing about it here, because it does not fit with their theory that Avery is guilty, unquote. Other incriminating evidence linking the Manitowoc County gravel pit to the crime scene. In addition to the human bone fragments found in the gravel pit, there is an abundance of old and new evidence establishing that the crime scene was in the gravel pit and not at Mr. Avery's residence and garage. Ms. Hallback's body was put in the Dassey Yonda burn barrel and transported to the gravel pit after sunset. The body was burned in the burn barrel, and the odor was detected by Travis Grohl on CTHQ, County or Highway Q. The Senton cadaver dogs reports corroborate that Ms. Hallback and her vehicle were in the gravel pit. Specifically, the cadaver dogs hit on 2 burn piles in an area of large concrete slabs in the gravel pit. Blood from an unknown male was found on a rock in the vicinity of the gravel pit bone piles and excluded Mr. Avery. That's Exhibit 11. Witness testimony has also linked the gravel pit to the crime scene. The edited flyover video shows no tire tracks on November 4, 2005, leading to where the RAV4 was found, but tire tracks leading to the RAV4 were present on November 5. That's interesting. Strongly suggesting that the vehicle was driven from the gravel pit onto the Avery property and planted, and that is Group Exhibit number 12, which is the flyover video. The state's illegal transmittal of the bones to the Hallback family. Mr. Avery's motion to stay and remand for scientific testing. On December 17, 2018, Mr. Avery filed a motion to stay and remand this appeal for scientific testing of several suspected human bones recovered from the gravel pit, Exhibit 1. Specifically, Mr. Avery proposed rapid DNA testing that has been successfully used to obtain DNA identifications from bones burned to a degree similar to those recovered from the gravel pit. This testing, argued Mr. Avery, is relevant and material because the identification of the bones as Ms. Hallback's is compelling evidence that her murder and mutilation did not occur in a location connected exclusively to Mr. Avery by the state. Thus, Mr. Avery argued, if the rapid DNA testing identifies Ms. Hallback's bones in the gravel pit, two inferences are reasonable. 1, Mr. Avery is not the murderer, and 2, the bones recovered from Mr. Avery's burn pit were planted. On December 28, 2018, the appellate court denied Mr. Avery's motion for DNA testing of the bones, finding that the scope of the pending appeal is limited to a review of the circuit court's orders, denying Mr. Avery's Wisconsin statute 974.06 motions, and that further scientific testing of evidence was not necessary to decide the instant appeal. Exhibit 2. Now we are on page 14 of 41. So again, this is long and I'm reading through this, so I'm not looking at what anybody is posting here. As I see somebody saying, what am I talking into? It's a microphone. All right, page 14 of 41. The discovery of the previously undisclosed September 20, 2011 police report and updated ledger sheets. After filing Mr. Avery's December 17, 2018 motion, current post-conviction counsel, oh my God, reading always makes my eyes tired and makes me yawn, sorry. Received a copy of a previously undisclosed police report from a third party. On January 24, 2019, current post-conviction counsel received her own copy of the September 20, 2011 report from the Calumet County Sheriff's Office, which is Exhibit 13. On February 8, 2019, current post-conviction counsel received updated ledger sheets that had never been previously disclosed to prior counsel. Those updated ledger sheets confirm the September 20, 2011 disposition of the human bone fragments to the Hallback family, which is Exhibit 14, and is thanks to Carol Ann Fitzgerald. The September 20, 2011 report reflects that Deputy Jeremy Hawkins of the Calumet County Sheriff's Department, along with Sergeant Investigator Mark Wiegert of the Calumet County Sheriff's Department, Attorney Thomas Fallon, and Attorney Norman Gahn, removed from evidence all property tag numbers that contained human bone. Exhibit 13. Attorney Norman Gahn and Prosecutor Fallon viewed the items under the property tags and, along with Dr. Eisenberg's report, quote, determined which bones could be returned to the Hallback family, unquote. Also Exhibit 13. Specifically, Dr. Eisenberg's report identifies by tag number human bone fragments from the gravel pit. Property tag numbers 7411, 7412, 7413, 7414, 7416, 7419, all is human, 7420 is undiagnostic, 7421, 7426, 7434, and 8675 as possible human. Dr. Eisenberg identified 7 tag numbers as having human bone fragments, 1 tag number as maybe human, and 3 tag numbers as being possible human, which is Exhibit 10. A chart based upon Dr. Eisenberg's report identifying the human bone fragments from the gravel pit that were returned to the Hallback family is attached and incorporated herein as Exhibit 15. A chart based upon Dr. Eisenberg's report identifying the 11 tag numbers of human bone fragments. Sorry about my dog playing with her chew toy right next to me. From Mr. Avery's burn pit that were returned to the Hallback family is attached and incorporated herein as Exhibit 16. A chart based upon Dr. Eisenberg's report identifying the 2 tag numbers as human bone fragments from the Dasyanda burn barrel, barrel number 2, that were returned to the Hallback family is attached and incorporated herein as Exhibit 17. At trial, Dr. Eisenberg testified as to the location of 3 burn areas: Mr. Avery's burn pit, the Dasyanda burn barrel, and 1 location is the gravel pit. In 2016, Suzanne Hagapian, however you say her name, of the Wisconsin State Public Defender's Office, who had been Mr. Avery's prior post-conviction and appellate attorney, provided to current post-conviction counsel's office her entire file pertaining to the Wisconsin State Public Defender's Office's representation of Mr. Avery. On September 20, 2011, the September 20, 2011 report is not present in current post-conviction counsel's file kept on the case. The affidavit of Kurt Kingler is attached and incorporated herein as Exhibit 18. On January 3, 2019, current post-conviction counsel contacted Ms. Hagapian to request that she confirm whether she had ever seen the September 20, 2011 report. Another yawn. Current post-conviction counsel has obtained an affidavit from Ms. Hagapian and is Exhibit 19. In her affidavit, Ms. Hagapian explains that her representation of Mr. Avery began in July 2007 and ended when the Wisconsin Supreme Court denied his petition for review on December 14, 2011. The Wisconsin Supreme Court's order was filed in Manitowoc County on December 15, 2011. On September 20, 2011, Ms. Hagapian and her co-counsel, Martha Askins, were Mr. Avery's attorneys of record. Ms. Hagapian has no recollection of having seen this police report before current post-conviction counsel delivered it to her on January 3, 2019. Further, Ms. Hagapian does not recall having a conversation with a representative of the state pertaining to tendering items of evidence from Mr. Avery's criminal case to the family of Ms. Hallback. Moreover, Ms. Hagapian avers that had she seen this report or had a conversation with a representative of the state regarding the return of items of evidence to the family of Ms. Hallback, she believes she would recall it. Attorneys Hagapian and Askins filed Mr. Avery's Wisconsin statute post-conviction motion on June 29, 2009. That motion was denied by the Circuit Court on January 25, 2010, and attorneys Hagapian and Askins timely appealed on February 10, 2010. This court affirmed the Circuit Court's order denying relief on August 24, 2011. Then, as discussed previously, on September 20, 2011, during the pendency of Mr. Avery's appeal, the Calumet County Sheriff's Department, together with Prosecutor Fallon and Attorney Gahn, arranged for the return of human bone fragments from the gravel pit and other human bone fragments from Mr. Avery's burn pit and the Dasyanda burn barrel to the family of Teresa Hallback. Mr. Avery has provided an affidavit that he, like his attorneys at the time, was never notified that human bone fragments had been given to the Hallback family. Exhibit 20. On September 22, 2011, attorneys Hagapian and Askins filed their petition for review with the Wisconsin Supreme Court. That petition was denied on December 14, 2011. Wisconsin's Preservation of Biological Evidence Statute, Wisconsin Statute 968.205, governs that preservation of physical evidence collected subject to criminal investigations, provides 2. Except as provided in sub 3, if physical evidence that is in possession of a law enforcement agency includes any biological material that was collected in connection with a criminal investigation that resulted in a criminal conviction, and the biological material is from a victim of the offense that was the subject of the criminal investigation, or may reasonably be used to incriminate or exculpate, right? Any person for the offense, the law enforcement agency shall preserve the physical evidence until every person in custody as a result of the conviction has reached his or her discharge date. 2M. A law enforcement agency shall retain to which sub 2 applies in an amount and manner sufficient to develop a, holy cow, deoxyribonucleic acid profile as defined in 939.74 from the biological material contained in or included on the evidence. 3. Subject to sub 5, a law enforcement agency may destroy evidence that includes biological material before the expiration of the time period specified in sub 2 if all of the following apply. A. The law enforcement agency sends a notice of its intent to destroy the evidence to all persons who remain in custody as a result of the criminal conviction, and to either the attorney of record for each person in custody of the state public defender. B. No person who is notified under Par A does either of the following within 90 days after the date on which the person received the notice. 1. Files a motion for testing of the evidence under 974.07. 2. Submits a written request for retention of the evidence of the law enforcement agency. C. No other provision or federal or state law requires the law enforcement agency to retain the evidence. It is beyond question that the state violated 968.205 when it failed to 1. Preserve the human bone evidence, and 2. Notify Mr. Avery and Ms. Hagapian of its intent to do the same because the human bone fragments were biological evidence collected in the course of the state's investigation of Mr. Avery, which ultimately led to his conviction. The purpose of the September 20, 2011 meeting was to identify the human bone fragments of Ms. Hallback and to return them to the Hallback family. Exhibit 13. Therefore, the human bone fragments recovered from the gravel pit are properly considered within the ambit of 968.205. Because 968.205 does not provide a remedy for convicted persons in the event of a violation, fashioning a remedy is left to the courts, an action Wisconsin courts have yet to take. Mr. Avery submits that this court should establish the most just and most logical remedy for such evidence preservation violations, i.e., such violations amounted to per se due process violations. This conclusion is borne out by controlling United States Supreme Court precedent addressing evidence preservations violations. Taken together, Trombetta and Youngblood comprise the line of constitutional jurisprudence that outlines the extent of the state's duty to preserve evidence. In each case, the United States Supreme Court promulgated a test to determine whether the destruction of evidence violates a criminal defendant's due process rights. The Trombetta test focuses on the probative value of the destroyed evidence and whether the evidence possessed a exculpatory value and was apparent before its destruction. The Youngblood test, for its part, disregards the probative value of the evidence in favor of examining the government's role in the circumstances that led to the destruction of the evidence. If a criminal defendant can satisfy either test, then a court will rule the destruction of evidence was a violation of due process and reverse the defendant's conviction. Going on to page 19 of 41. We're just about halfway done with all of this. And sorry, I know there's a lot of people that don't care about reading all this and they just want to know, what does it mean? But we're going over all of this now, and then we can break it down and discuss it. But we're going to read through it this one time. All right, so page 19 of 41 of the filing. The Due Process Clause of the 14th Amendment of the United States Constitution imposes a duty on the state to preserve exculpatory evidence. The state's failure to preserve evidence violates and defendants' due process rights if police, 1, failed to preserve evidence that is apparently exculpatory, or 2, acted in bad faith by failing to preserve evidence that is potentially exculpatory. And that's from State v. Greenwald. While the United States Supreme Court did not clearly state whether the Youngblood test overruled the Trombetta test, Wisconsin courts view Youngblood as a separate test that complements Trombetta. Greenwald 2, blah, blah, blah. That is, Wisconsin courts determine whether the Trombetta or Youngblood tests apply in a case based upon the perceived exculpatory value of the evidence. In Greenwald 2, the Wisconsin Court of Appeals set forth this approach to the Youngblood and Trombetta tests after examining the differences between the tests. Because Youngblood added a bad faith determination to the Trombetta materiality, blah, 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 inquiry, the Greenwald court reasoned that the Supreme Court intended to create two complementary preservation of evidence tests. The Greenwald 2 court synthesized a two-step analysis to address the destruction of evidence. The outcome of this analysis depends upon two specific examinations. 1, whether by looking at the facts surrounding the crime itself, the destroyed evidence was apparently exculpatory or potentially exculpatory. And 2, if the evidence is merely potentially exculpatory, whether the destruction of the evidence results from the government's bad faith. Now we're on page 20 of 41. Thus, in Wisconsin, the adoption of either Trombetta or Youngblood depends upon the probative value of the evidence at issue. If the evidence is apparently exculpatory, Wisconsin courts will apply the Trombetta test. However, to trigger the Youngblood test, all that need be shown is that the government destroyed potentially exculpatory evidence. Wisconsin courts have followed this line of reasoning. For example, the Court of Appeals stated in State v. Parker, quote, a defendant's due process rights are violated if the destruction of evidence, 1, if the evidence destroyed was apparently exculpatory and of such a nature that the defendant would be unable to obtain comparable evidence by other reasonable means, or 2, if the evidence was potentially exculpatory and was destroyed in bad faith, unquote. While the Trombetta and Youngblood evidence preservation doctrines originally applied only when evidence was destroyed pre-trial, the Wisconsin Court of Appeals stated that Trombetta and Youngblood and Wisconsin's two-part Greenwald test are applicable to the post-conviction destruction of evidence in Parker. Mr. Avery submits that following Parker, the Greenwald two-part analysis should be applied to address the state's violation of the DNA evidence preservation statute in the instant case. Now we're going on page 21 of 41. All right, here we go. When examining the test set forth in Greenwald 2, Wisconsin courts apply certain presumptions implicit in the DNA preservation statutes. By codifying a right to the preservation and testing as provided in Wisconsin statute, blah, 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 of evidence, the DNA preservation statute creates 3 presumptions regarding both the materiality, I can't say that word, of the evidence and the circumstances surrounding the destruction or loss. A. Materiality. First, the statutes presume that all biological evidence collected in the course of a criminal investigation and covered by the statutes is material. The applicability of either Trombetta or Youngblood depends upon the material of the evidence that was lost or destroyed. A hurdle in applying these tests is the impossibility of knowing definitively the material value of evidence that no longer exists. The Supreme Court in Trombetta addressed the difficulty of extrapolating material from lost evidence. Quote, courts face the treacherous task of divining the import of materials whose contents are unknown and very often disputed, unquote. However, in the context of addressing the materiality, why can't I say that, of evidence lost or destroyed in violation of Wisconsin statute, blah, blah, the Wisconsin legislature has already resolved that problem, especially when considered together with blah, blah. The DNA evidence preservation statute demonstrates the Wisconsin legislature's recognition of the importance of post-conviction DNA testing. These statutes, taken together, provide for the preservation of biological evidence and, in many instances, DNA analysis thereof. The codified right to DNA preservation and testing shows the legislative intent to ensure that DNA testing of biological evidence plays, quote, a significant role in the suspect's defense, unquote, and efforts to obtain post-conviction relief. Therefore, the Wisconsin legislature, through the DNA preservation statute, has placed preserved biological evidence in the class of evidence the United States Supreme Court deemed material as defined in Trombetta and Youngblood. B. Potentially exculpatory evidence preserved under Wisconsin statute, blah, blah. Second, following from this presumption of materiality, the DNA evidence preservation statutes further presume that, in every case, biological evidence collected in the course of a criminal investigation is at least potentially exculpatory, as defined in Greenwald 2. In the context of DNA evidence, apparently exculpatory evidence contemplates instances where results from testing or retesting of biological evidence that excluded the petitioner would exonerate him or her of the crime of conviction. Similarly, potentially exculpatory DNA evidence refers to evidence of cases where, quote, if subjected to DNA testing or retesting, exculpatory results would support the petitioner's claim of innocence, unquote. In line with the Supreme Court's reasoning in Youngblood, this category includes evidence that was, quote, simply an avenue of investigation that might have led in any number of directions, unquote, and evidence about which, quote, no more can be said than that it could have been subjected to tests, the results of which might have exonerated the defendant, unquote. These categorical requirements for potentially exculpatory evidence necessarily apply to biological evidence covered by the DNA evidence preservation statute, because preserved evidence test results allow, quote, reasonable persons to disagree as to whether the results of DNA testing rule out the possibility of guilt or raise a reasonable doubt of guilt, unquote. Therefore, evidence covered under the biological evidence preservation statute must be deemed at least potentially exculpatory, and the loss of destruction of such evidence triggers, at minimum, the Youngblood due process analysis. C. The DNA evidence preservation statute presumes that every violation thereof constitutes bad faith. Lastly, because the statutes prescribe the normal course of conduct for Wisconsin law enforcement agencies regarding the collection, preservation, and eventual destruction of biological evidence, every violation of the statutes constitutes bad faith as defined by Youngblood and Greenwald 2. In Youngblood, court reasoned that law enforcement actions suggesting bad faith arise when the, quote, police themselves, by their conduct, indicate that the evidence could form a basis for exonerating the defendant, unquote. This consideration, in turn, hinges, quote, on the police's knowledge of the exculpatory value of the evidence at the time it was lost or destroyed, unquote. In these cases, bad faith exists when the conduct of the police is outside the scope of normal practice. The Youngblood court's definition of bad faith takes for granted that there are times when the police will not know whether evidence was material before its loss or destruction. The DNA preservation statute eliminates this assumption by creating an affirmative duty to preserve all biological evidence taken from the crime scene. Thus, law enforcement agencies are on notice that biological evidence is deemed important to the successful administration of criminal justice, and therefore may not claim ignorance that the destroyed evidence was at least potentially exculpatory. Wisconsin statute blah blah imposes certain duties upon law enforcement agencies. At the most basic level, the state bears a duty to preserve all biological evidence collected during the course of an investigation that leads to a conviction. Additionally, the statute sets forth the steps that the state must take before lawfully destroying such evidence in its possession. Because a violation of the DNA preservation statute means the state did not abide by either the requirements of preservation or the proper destruction of the evidence as required by law, such conduct constitutes bad faith. This conclusion is not undermined by the Wisconsin Court of Appeals' adoption of the official animus standard in Greenwald 2. The Greenwald 2 court emphasized that bad faith does not exist when the destruction of evidence was due to inadvertent or negligent actions on the part of law enforcement. However, this exclusion only pertains to two situations where evidence preservation was, one, required by non-codified law enforcement agency policy, or two, not required by any policy. Mr. Avery submits that a violation of state law goes far beyond the negligence standard that the official animus framework was formulated to replace. That is, a violation of state law should not be analyzed within the context of mere negligence or inadvertence. Indeed, such a violation should immediately trigger official animus as adopted in Greenwald 2 as a per se showing of bad faith under Youngblood. The state was aware of the apparent exculpatory value and materiality of the bones prior to their destruction because of the pre-trial FBI examination, trial stipulation, and April 4, 2007 order. The apparent exculpatory value and materiality of the bones was apparent to the state prior to their destruction, as is demonstrated by its efforts to conduct a DNA examination of the bones pre-trial. The examination by the FBI was unsuccessful at that point in time. The parties entered into a stipulation at trial, which stated that the FBI conducted no DNA examination of the possibly human bones from the quarry pile south of the Avery salvage yard due to the degraded condition of the bone fragments, which is Exhibit D at Exhibit 25 and Exhibit E also at Exhibit 25. Both the apparent exculpatory value and materiality of the bones was established and would have been apparent to the state prior to their destruction by the attempted FBI testing and the stipulation between the parties, which was entered at Mr. Avery's trial, which are Exhibits D and E at Exhibit 25. Post-trial, the state was aware of the apparent exculpatory value and materiality of the bones prior to their destruction when the trial court entered an order on April 4, 2007 for the preservation of blood evidence and independent defense testing. This order contemplates and allows future DNA testing by Mr. Avery. In its order, the trial court gave Mr. Avery the opportunity to, at any time, submit items of evidence for DNA testing. Both the apparent exculpatory value and materiality of the bones was established by the April 4, 2007 order. D. Application. The presumptions created by the DNA evidence preservation statute shape the analysis that Wisconsin courts should undertake when confronted with instances such as in the instant case where a law enforcement agency violated the statute. This analysis is grounded in the two-part test set forth in Greenwald 2. However, it differs to the extent Wisconsin courts apply the presumptions created by the DNA evidence preservation statute. These presumptions, as set forth above, dictate issues as the heart of the test. And sorry, my cell phone's ringing. I have the sound turned off on my phone, but not my iPad, so it's ringing through my iPad. We're going on page 26 of 41. Trombetta's apparent exculpatory requirement. Now she's calling me again. Can I turn my sound off here? Where is it? I can't find it on this. There it is. Right? Sorry. Turn off. I don't know if I turned it off. Sorry. If she calls again, you're going to have to deal. Sorry. All right. Trombetta's apparently exculpatory requirement is met. As described more fully above, the first step in the Greenwald 2 analysis is an inquiry into the first two steps of the Trombetta test, whether the destroyed evidence was apparently exculpatory. Greenwald 2, blah, blah, blah. This examination asks whether, if the destroyed evidence was subjected to testing or retesting, favorable results would exonerate the petitioner and whether the state was on notice of this fact. If the state failed to preserve evidence that was apparently exculpatory, and if the state was aware of its apparent exculpatory nature, then the court must vacate the conviction. As stated previously, the apparent exculpatory value of the bones has been demonstrated by the state's efforts pre-trial to have the FBI test the bones and the subsequent stipulation in April 4, 2007 order. Youngblood's potentially exculpatory combined with bad faith requirement is met. If, however, the evidence is not deemed apparently exculpatory, then Wisconsin courts should apply the Youngblood test under the second step of the Greenwald 2 analysis. Alternatively, under the Youngblood test, courts would examine whether the evidence was potentially exculpatory, and if so, whether the police acted in bad faith when they destroyed the evidence. In light of the presumptions created by the DNA evidence preservation statute, the trial stipulation, the pre-trial FBI examination, and the April 4, 2007 order, as described fully above, mandates that the evidence be considered potentially exculpatory. Next, the court considers whether the law enforcement agency acted in bad faith. As set forth above, the presence of bad faith is presumed every time the Wisconsin statute, blah, blah, evidence preservation statute is violated, which are Exhibits 19 and 20. Here, the failure to give notice to Mr. Avery and his attorneys violated the statute. Additionally, the state violated the April 4, 2007 trial court order by giving the bones back to the Hallback family. By returning the gravel pit bones to the Hallback family, the state has admitted that the bones are human and that they belong to Ms. Hallback. The state cannot credibly argue that it returned animal bones to the Hallback family for burial or cremation. Both of these violations mean that the state acted outside the scope of its normal practice by destroying evidence it knew had to be preserved in compliance with Wisconsin statute, blah, blah, and the April 4, 2007 trial court order. This is the first paragraph on page 27 of 41. And so that's a biggie right there. All right. So the state's ongoing efforts to conceal the destruction of the bones. Oh, and now they're sending me, I'm just getting emailed, the court is sending me some new exhibit that she just filed. We'll look into all that later. The state's ongoing efforts to conceal the destruction of the bones. As previously discussed, Mr. Avery filed a motion to stay, appeal, and remand the cause for new scientific testing of the gravel pit bones. See Exhibit 1. When the state responded to Mr. Avery's motion, it never mentioned that it had effectively destroyed the bones that would have been tested had the motion been granted. On February 25, 2019, the appellate court order noted that, quote, the state's objection does not address the merits of Avery's claimed statutory and constitutional violations, and it has not responded to Avery's supplemental filings alleging the possible destruction of evidentiary items which it appears the parties previously agreed to preserve, which is Exhibit 8. Both of the state's responses indicate bad faith and a lack of candor in failing to address the destruction of the gravel pit bones without informing Mr. Avery, his attorneys, and the court, which is Exhibit 4. Response in opposition to the petition to stay the appeal and remand this case to the circuit court is attached and incorporated herein as Exhibit 21. The state also agreed in a September 18, 2017 meeting with current post-conviction counsel to arrange for the testing of the suspected human pelvic bone. It is clear that the parties have construed the scope of the April 2007 order to permit testing of a variety of biological samples deemed relevant to the instant case. The state was on notice of this agreement in September 2011 when it effectuated the destruction of human bone fragments recovered in the gravel pit. The state knew it bore a duty to preserve biological material at the time it effectuated the potential destruction of the human bone fragments without notifying Mr. Avery and his attorneys. The state, by taking these actions, acted in bad faith and with official animus as defined by Youngblood in Greenwald 2. In light of the information that the pelvic bone, Calumet County Sheriff's Department number 8675, was categorized as human and therefore would have been returned to the Hallback family, undersigned counsel made 2 urgent email requests of Prosecutor Fallon for confirmation of its whereabouts. Exhibit 7. To call undersigned counsel immediately on her cell phone to confirm whether or not the state was in possession of the human pelvic bone number 8675. Mr. Fallon has consistently represented to undersigned counsel for the last 3 years that the state was in possession of the pelvic bone. Prosecutor Fallon never returned Ms. Zellner's telephone call and apparently was instructed not to by his co-counsel, attorney Mark Williams. Mr. Williams inadvertently called current post-conviction counsel's cell phone at 9:13 a.m. on February 13, 2019 and left a message intended for Prosecutor Fallon, which stated, quote, "Hi, Tom. This is Mark Williams. I'll send you an email later today, but I don't think we should do anything or respond to her at all until tomorrow when we look into the bag and see exactly the pelvic bones are in there or not. So I would not respond until we look into the bag tomorrow morning, and then we can talk about it before we send a response. Thanks a lot. Bye." On February 17, 2019, Prosecutor Fallon left a voicemail on current post-conviction counsel's cell phone admitting, quote, "Yes, many bone fragments were returned to the family," unquote. And a CD of those voicemails are Group Exhibit 22. Mr. Avery's experts, Drs. DeHaan, Symes, and Selden. Dr. DeHaan establishes that the bones were planted in Mr. Avery's burn pit. Current post-conviction counsel has developed new evidence through her expert, Dr. John DeHaan, who has ruled out, based upon new discoveries in forensic fire science, that Ms. Hallback's Ms. Hallback's body was burned in Mr. Avery's burn pit. Additionally, Dr. DeHaan has demonstrated that the bones were planted in Mr. Avery's burn pit. This evidence also meets the trombetta requirement of apparently exculpatory. Therefore, Dr. DeHaan's opinions greatly increase the evidence of Mr. Avery's actual innocence and make the destruction of the gravel pit human bone fragments an even more egregious constitutional violation, and his affidavit is Exhibit 23. Dr. Symes has identified human bones in the gravel pit. Another excerpt of current post-conviction counsel, Dr. Stephen Symes, a renowned forensic anthropologist, has offered the opinion that Dr. Eisenberg correctly determined in her second anthropological report, which is Exhibit 10, that the gravel pit bones were human based upon her visual inspection of the bones. Dr. Symes has also been able to identify human ribs and additional human pelvic bones from the Calumet County Sheriff's Department items number 7411 and 7412, which is his affidavit is Exhibit 24. Dr. Selden establishes the state's bad faith by commingling the bones when they were returned to the Hallback family. Mr. Avery's expert, Richard Selden, MD, PhD, has offered the following opinions regarding the commingling effect of the bones. 1. Because the bones were commingled and their labels removed, it is no longer possible to determine if the victim's bones were present in the gravel pit or if the bones in the gravel pit were human. 2. Furthermore, presuming the commingled bones, including those from the gravel pit, were cremated, the ability to generate a DNA ID has been irreversibly lost because, following cremation, the sizes of the genomic DNA fragments are too small to yield amplified DNA of the size required. The evidentiary value of testing has been destroyed. 3. Alternatively, presuming the commingled bones, including those from the gravel pit, were buried, the DNA itself has likely been destroyed due to environmental conditions and microbial degradation over the last 8 years. As noted in the preceding paragraph, even if such testing could be done, it would be useless because the bones from all 3 sites were commingled. 4. Testing results would be scientifically invalid because the controlled conditions, including but not limited to a clear understanding of the location of each of the bone fragments, were lost by the actions of the state on September 20, 2011 in disposing, mingling, and destroying the human bones. Dr. Selden also notes in his affidavit that advances in the last several months have resulted in the development of even more sensitive DNA testing that, quote, allows a fraction of DNA from a single cell to be identified as being of human origin. The opportunity to perform scientific testing to definitively confirm the state's forensic anthropologist's determination that the bones were human has been irretrievably lost. Blah, blah. I'm having a hard time with words now. For all of the above stated reasons, unquote. And his affidavit is Exhibit 25. Dr. Selden establishes that more accurate and probative results could have been obtained from the gravel pit bones with newly developed DNA technology. As stated in his previous affidavit, Dr. Selden opined there would have been a, quote, reasonable likelihood of more accurate and probative results, that the gravel pit samples would generate DNA. Sorry, somebody else calling me now, and I did not obviously turn off my sound. Would generate DNA identifications if processed using anti-rapid DNA technologies, unquote, which is Exhibit 1. Dr. Selden has offered specific details about the improvement in the DNA technology that would have resulted in a DNA identification being made of the gravel pit bones. 7. My understanding is that in 2006, the FBI determined that performing DNA analysis, including mitochondrial DNA analysis on the bones in the instant case, would not be effective due to the degraded nature of the remains. I believe that the decision to defer DNA testing was reasonable at the time because the then current technology was unlikely to be successful. 8. Today, the decision to defer testing has been validated. DNA identification technology is dramatically improved as compared to the state of the art in 2006, and my expectation, as originally presented in my affidavit of 17 December 2018, is that this improved technology will allow the successful DNA typing of the bones in the instant case. There are 3 major advances that led me to this conclusion. 9. First, DNA typing technology in general and the Andy system in particular are much more sensitive than was the case in 2006. Improved short tandem repeat primer design and synthesis, improved amplification reaction mixes, and better controlled thermal cyclers combine to dramatically reduce the limit of detection as compared to 13 years ago. As of approximately 2014, picogram quantities of genomic DNA can now be readily and routinely directed, at least a 50-fold improvement over the 2006 state of the art. 10. Second, the ability of degraded DNA to be analyzed has been significantly advanced over the past 13 years. These advances have been driven in large part by the FBI's 2017 requirement to utilize 20 CODIS STR markers instead of 13. The addition of new CODIS STR markers and mini STR markers includes that these can identify smaller, more highly degraded DNA fragments than possible in 2006. 11. Third, in the Andy system is much more rapid than conventional laboratory bone processing today, let alone that of 2006. Andy allows results to be generated in less than 2 hours, as compared to the months to years characteristic of conventional processing. One of the major advantages of speed is that it allows many more bone samples in the instant case to be processed essentially immediately. If we assume, for example, that we possess 12 samples during the first day, the results from this work will inform the approach to processing the next set of samples on the following day. This immediate feedback, allowing forensic DNA identification to be optimized in real time, was not possible in 2006. In that era, results might become available months to years later, far too long to have a practical impact on sample processing optimization. Again, for the reasons noted above, it was highly unlikely the 2006 technology could yield useful results under any circumstances. 12. On June 4, 2018, the Andy Rapid DNA ID system received National DNA Index System, NDIS, approval from the FBI. The approval allows all accredited forensic DNA laboratories to utilize the Andy system for the processing of buccal swabs and to submit DNA ID data to the federal DNA database, CODIS, and to search the federal DNA database with data generated from the Andy system. The FBI has publicly stated that it intends to allow NDIS-approved rapid DNA systems to be utilized to test arrestees while in custody in police booking stations as required by the Federal Rapid DNA Act of 2017, which was passed unanimously in the House of Reps and Senate. A peer-reviewed manuscript describing the NDIS approval study was published in Forensic Science International Genetics in February 2019 and is Exhibit 25. We are now going on page 33 of 41. Clearly, the testing proposed by Dr. Selden would have met the requirements of State v. Plude. Plude held, quote, when moving for a new trial based on the allegation of newly discovered evidence, a defendant must prove, quote, 1, the evidence was discovered after conviction, 2, the defendant was not negligent in seeking the evidence, 3, the evidence is material to an issue in the case, and 4, the evidence is not merely cumulative, unquote. The state has deprived Mr. Avery of the opportunity to meet the Plude requirements and to obtain a new trial. The state, by its actions, has admitted that the bones are not only human, but also that they belong to Ms. Hallback. The state, without notifying Mr. Avery and his attorneys, and during the pendency of Mr. Avery's direct appeal, caused material and apparently and potentially exculpatory evidence to be transmitted to the Hallback family for its destruction by cremation or burial. According to federal and state due process jurisprudence regarding the state's duty to preserve evidence, the appropriate remedy for a violation of Wisconsin's DNA evidence preservation statutes and the additional violation of the April 4, 2007 trial court order in and of itself should result in the reversal of Mr. Avery's conviction. The violation of both orders is indisputably a due process violation that mandates that Mr. Avery be granted a new trial. Sweaty Sweats, false representations during closing argument. The trial statements of Sweaty Sweat indicate that he understood the exculpatory value of the gravel pit bones because he did everything to mislead and misrepresent to the jury that these bones were human. Sweaty Sweat violated Mr. Avery's right to due process, where he concealed information and misrepresented to the jury during closing argument that the only human bone fragments were discovered in Mr. Avery's burn pit. Quote, so the state believes and the state argues that there isn't any question that is, in fact, Teresa Hallback and her bones and her remains and her teeth that are recovered just a few feet behind Mr. Avery's garage and trailer. Next quote. But I guess most importantly, when the bones of the victim are found 20 feet or so behind the property belonging to Mr. Avery, you stop looking. You stop looking for people like boyfriends or other customers or this kind of search, unquote. And hold on, let me put my dogs out because they're going crazy right now. Come on, outside. And yes, so far, Eric, I'm just reading the filings. We're getting through the filings and then we'll break it down. We're only reading through it this one time. All right. Sweaty Sweat attempted to refute that the bones had been planted in Mr. Avery's burn pit by telling the jury the following, quote, bones were moved in this case. There's no question of that. No question of that. Who moved the bones? To the state or for the theory of the prosecution is easy. Mr. Avery moved the bones. He moved the big bones. He moved the big bones, the ones he could identify as human bones, from his burn pit over to his sister's burn barrel. All right? That's a couple 100 feet away. If you think about the selfishness involved in that particular act, that I think is one factor. But I guess more importantly is directing attention away from himself. Might be that first night, might be the 31st, might be the 1st or the 2nd, because he has got a couple of days, as it turns out, before the police officers actually start the investigation, unquote. Sweaty Sweat deliberately misled the jury about the human bones in the gravel pit when he made the following statements. Quote, these bones in the quarry, I'm going to take about 20 seconds to talk about because the best anybody can say is that they are possible human. What does possible human mean? Well, it means we don't know what it is. All right. Next quote. The best anthropologists in the world don't know what these bones are. Dr. Eisenberg didn't know what they were. Mr. Fairgrieve didn't know what they were. He agreed with that. Next one. And you heard a stipulation being read to you by a person by the names of Les McCurdy. Stipulation just means an agreement between the parties that these bones, we felt it important enough, were sent out to the FBI. And Les McCurdy from the FBI determined that these bones were so degraded that they were in such a shape that even through testing, what's called mitochondrial DNA testing, whether they were human or not, could not, even by the FBI, be determined. Next quote. So the bones in the quarry are really not evidence in this case. And so Mr. Strang has made a big deal out of showing you maps and a little flag and things like that about a possible bones. Again, speculation, conjecture is not part of this case. Facts are going to be what decides this case, unquote. Sweaty Sweat Sweat was well aware of the contents of these discovery disclosures prior to making his closing argument. He knew that 4 piles of human bones had been discovered in the gravel pit, and he actively misled the jury into believing that none of the bones were human. The Calumet County ledger sheets, Dr. Eisenberg's report, and the gravel pit bone pile maps clearly document that there were numerous bone fragments in the gravel pit that were human, which are exhibits 9, 10, and 11. Quote, the proper role of the criminal prosecutor is not simply to obtain a conviction, but to obtain a fair conviction, unquote. That's from Brown v. Borg. Thus, a prosecutor may not knowingly argue false evidence to the jury. A prosecutor's knowingly false statements during closing argument violate a criminal defendant's right to due process. In Miller, the defendant was charged with sexually assaulting and murdering the victim. A pair of men's underwear shorts with dark reddish-brown stains was recovered 3 days after the murder, approximately a mile from the crime scene. At the time of trial, the prosecutor knew that the shorts had paint on them, and he even possessed a police report stating that the stains consisted of paint. Nevertheless, a prosecutor consistently and repeatedly misrepresented to the jury that the paint stains were actually the victim's blood. The United States Supreme Court concluded that the prosecutor deliberately misrepresented the truth and in doing so violated the Fourth Amendment. In United States v. Tony, 3 masked men robbed a bank in Ohio. Shortly after the robbery, money taken from the bank was found during a search of Tony's residence. Tony claimed that he was going to participate in the robbery with Willie and Henry, but got nervous and backed out of the plan. A third man, Jimmy King, took his place. Tony maintained that he won the stolen bills the next day when gambling with a group of friends, which included King. King was arrested and gave a statement in which he admitted to gambling with Tony on the date of the robbery. At Tony's trial, King invoked his Fifth Amendment privilege against self-incrimination. The trial court then held that King's post-arrest statement was inadmissible. During closing argument, the prosecutor argued as follows, quote, I would ask you to also concentrate on this one fact. Have you heard any testimony from any witness, either the government brought forward or the defense brought forward, that Jimmy King did any gambling that night? Jimmy King was there, but Jimmy King, no witness has testified to you or told you did any gambling on the night of the 13th or the 14th, and there is no testimony that he was gambling or anywhere near a gambling place on the 13th or 14th in the afternoon. I submit to you, cut through the smoke screen. It is a defendant's contention he got the money from Jimmy King, unquote. The prosecution went on to argue that Tony's defense should be rejected because he had not produced any evidence to support his claim that he had been gambling with King after the robbery. The Sixth Circuit reversed Tony's conviction. The court noted that the prosecutor argued that there was no evidence to support Tony's claim, knowing full well that evidence did corroborate his claim, i.e. King's statement. The court held the prosecutor's knowingly false argument to be foul play and reversed Tony's conviction. Several other cases likewise hold that where a prosecutor makes closing argument he knows to be untrue, even if not necessarily contradicted by the evidence or testimony admitted at trial, the defendant's right to due process is violated. Sweaty Sweat Sweat clearly concealed that there were numerous gravel pit bone fragments that were human and dismissed the suspected human pelvic bone position of trial defense counsel as speculative. Because of Sweaty Sweat Sweat's misrepresentations to the jury, Mr. Avery's conviction must be reversed. Page 38 of 41. Disqualification of Judge Sutkowitz, which is Judge Flowers. Although not strictly required by the Wisconsin Code of Judicial Conduct, Judge Flowers should disqualify herself from presiding over any further proceedings in this matter. By virtue of having presided over the prior civil case filed against Mr. Avery by the Hallback family for the death of Teresa Hallback, Judge Flowers should recuse herself from the pending post-conviction case, and it should be reassigned to a different judge. Judge Willis recused himself from the Hallback civil suit because he had presided over the criminal case, including the direct appeal and post-conviction. Quote, "Our legal system is based on the principle that an independent, fair, and competent judiciary will interpret and apply the laws that govern us," unquote, from the Code of Judicial Conduct. Quote, "A judge shall respect and comply with the law and shall act at all times in a manner that promotes public confidence in the integrity and impartiality of the judiciary," unquote. A judge is required to recuse himself or herself in a proceeding when, quote, "well-informed persons knowledgeable about judicial ethics standards and the justice system and aware of the facts and the circumstances the judge knows or reasonably should know would reasonably question the judges to be impartial," unquote. And now another quote. "Under this rule, a judge must recuse himself or herself whenever the facts and circumstances the judge knows or reasonably should know raise reasonable question of the judge's ability to act impartially, regardless of whether any of the specific rules in SCR 60.04 applies," unquote. On March 24, 2006, a wrongful death lawsuit was filed against Mr. Avery on behalf of Ms. Hallback's estate. Hallback versus Avery et al., Manitowoc County, case number blah blah. On or about October 29, 2013, Judge Flowers was assigned to preside over the lawsuit. On November 21, 2013, plaintiff's counsel filed a motion to voluntarily dismiss the lawsuit. On November 25, 2013, Judge Flowers held the plaintiff's motion in abeyance pending the resolution of Mr. Avery's criminal proceedings. It was not until June 8, 2015, after Mr. Avery sent correspondence concerning the voluntary dismissal, that Judge Flowers granted the plaintiff's motion to voluntarily dismiss the lawsuit. Having presided over the lawsuit filed by the Hallback family against Mr. Avery, Judge Flowers' ability to be impartial in the ongoing criminal proceedings against Mr. Avery is reasonably subject to question. Indeed, under the American Bar Association Code of Judicial Conduct, a judge must is underlined, disqualify herself if she previously presided over the matter in another court. And Wisconsin tribunals in similar situations have determined that their disqualification from a criminal proceeding after having presided over a civil lawsuit involving the same subject matter is appropriate. Because Judge Flowers presided over the civil lawsuit in which Mr. Avery was accused of causing Ms. Hallback's death, she should disqualify herself from further participation in the criminal proceedings involving Mr. Avery. In a similar vein, Judge Flowers' prior affiliation with Sweaty Sweat Sweat likewise calls her impartiality into question. Judge Flowers and Sweaty Sweat Sweat served together on the 5-member Crime Victims' Rights Board in 2007 to 2008, the exact time frame during which Mr. Avery's criminal case went to trial and he was convicted. Again, Judge Flowers' association with Sweaty Sweat Sweat, advocating on behalf of crime victims at the same time Mr. Avery's criminal case went to trial, raises reasonable questions about her impartiality. Conclusion. For all of the above stated reasons, Mr. Avery is requesting that his conviction be reversed and that his cause be set for a new trial and for any other relief that this court deems appropriate to grant, dated this 11th day of March 2019. So there you go. That's the whole thing. I don't know if it's even needed for me to go over the to pull up the exhibits and go through them, because they're just things that go over this. So I'll just scroll through now in the things that you guys have said. But to summarize all of that just took me an hour and 25 minutes to read that whole filing, not including exhibits that I haven't even looked at yet. This is all just, again, talking about that bone. So there were bones in the burn pit that was behind Stephen's garage. There were some bones that were found in the quarry behind the salvage yard. And then there were these pelvic bones that were found at the Manitowoc gravel pit, which is the farthest point away. And they hid from Stephen's lawyers that in 2011, they gave those gravel pit bones to the Hallback family. When they turned over all evidence, when Kathleen took the case, they didn't include the part when Wiegert signed out those bones and Karen Hallback signed to receive them, that they went to a funeral home. What happened at the funeral home, we don't know, if they were cremated or burned, but it doesn't matter what happened with them, because as it states in their legal word, commingled, I don't know what that is that I just got. And sorry, I say a lot when I talk and I'm not reading. You've broken the chain of custody. Those bones were to remain in evidence as long as Stephen and Brendan are incarcerated, because our science is always changing. And so at that time when this was originally tried, they did not have the technology that would be able to identify these burned bones. But they're supposed to keep them. And if they are going to destroy them or do something with them, they can only do so by notifying Stephen and his lawyers and getting his permission. They didn't do that when they gave the Hallback family the bones. And also the problem is Sweaty Sweat Sweat. And yes, for people that are asking who Sweaty Sweat Sweat is, that's Ken Kratz, because I said in an article that I wrote that he was very sweaty, and his sister wife, daughter wife, got all offended by that. So I forever just refer to him as Sweaty Sweat Sweat, because he's a sweaty pig and he makes up things like sweat DNA that doesn't exist. So anyway, Sweaty Sweat Sweat claimed that the bones that were found at the gravel pit were not to be paid attention to because it's not even human. We don't even know what they are. But by them then giving those to the Hallback family, you're admitting that it's Teresa, because why else are you just going to give animal bones to the Hallback family? Right? So why would you give it to the Hallback family? And regardless of no matter what bones they are, human or animal, they you have to ask Stephen's permission to give away evidence. And they didn't do that. And even if these bones were just put in a box and the family was keeping them for whatever reason, you've broken the chain of custody. And so you can't be sure that those bones are now the bones. So you've destroyed them. They can't test these bones. So that's what her huge filing is about today, is more of just centering on the Manitowoc gravel pit bone. And that it was always in agreement between whoever was representing Stephen, whether it was Buting and Strang or the post-conviction people or Kathleen. The state has always said that those bones are in their custody. And if they want them, they can have it for testing. But now when Kathleen asks for them, she gets the runaround. And only due to people FOIAing, which is the Freedom of Information Act, to get documents from this case, that they were able to determine that this pelvic bone, number 8675, was given to the Hallback family. When Kathleen received everything, that part of the ledger was gone. They didn't include that they gave it to the Hallback family. So as far as Kathleen knew, it was in evidence. So, and that was Carol Ann Fitzgerald, who is a retired police officer in Australia, who just poring over all of this. She then sent it to Kathleen. Did you see this? And this is what I've always told people. You never know for sure. Yes, Kathleen is brilliant. Yes, she's got a lot of brilliant minds working with her. But there's a lot in this case, and things can be missed. So send it to Kathleen. It doesn't hurt to send her an email saying, hey, XYZ. And that's what Carol Ann Fitzgerald did. She's the one that stood up and gave it to Kathleen, and this is what it's produced. So what Kathleen is saying is that he should get a new trial because this evidence is gone now. And also, you know, I would love to hear from his jury. Now, we know some of the people on his jury were planted, so you're not changing their minds no matter what happens, since they were affiliated with Manitowoc County Sheriff's Department. But I'd be curious to know what they would think about this if they found out that there were Teresa's bones at the gravel pit. That's nowhere in Sweaty Sweat Sweat. And yes, I see Heather saying it shows I'm juvenile in poor taste, and keep it serious. I will forever call him Sweaty Sweat Sweat. So the guy dishes it and he's going to take it. And yes, I'm juvenile. Stephen was robbed of a fair trial by them covering this bone and hiding this bone. So he should be able to get a new trial. He should be able to be released on his own recognizance, no bond. He's innocent because everything you have here now, everything is corrupt. So let him go free. State can decide if they're going to file charges against him again and take it on over again. So from the filing, the court's ruling prior to this, what we had heard before was that Kathleen had 14 days to file anything additional that she wanted included in this whole bone thing, which is what we just read through today. And it said then From that, the next time we have 30 days, waiting 30 days for the next response. Don't ask me legal shit. I don't know the legal stuff. I just remember reading in that there was the 14 days, and then from the 14 days, there's 30 days. So, so it is March 12th. So be looking, we're looking mid-April for the next thing. But so the bottom line in all of this, there's nothing new from this filing from what we already know from what she did before. This is all about this bone that's at the Manitowoc gravel pit. And that was not in Sweaty Sweat's narrative on what happened to Teresa. Because, yes, Stephen is no genius, but why is he going to do anything all the way at the gravel pit? A quarter mile away. And also, if you drive it, you have to go way around everything. If you walk it, and you just go through, because it's gravel pit, quarry, salvage yard, trailer. So, but why would he? I'm sprinkling stuff everywhere, but I'm going to put the bulk of it at my own place. That he even Stephen with a low IQ is not dumb enough to do that. Just not. So they were just doing their narrative and didn't care to look at anything else. So, yeah, and here's another one saying diminishes my credibility for calling him Sweaty Sweat. Well, sorry, but I'm still going to. Scrolling through your comments. What's the new evidence? Let me see. Let me pull up that email on this one. I don't know. It's because I was looking to get all these documents, and I'm not because they told me to pay for all of this stuff. It was going to cost me $750. They're charging $1.50 a page, which I also think is really ridiculous. I get it when you're printing stuff out, but you're not printing this. You're just emailing it to me. So, yeah. So for all the current, the filing, the 41 pages of the filing, and then there's the 27 exhibits. They wanted $750 for. Hold on, I'm trying to open this email. All right. Attorney Zellner's office just filed an exhibit that was overlooked during yesterday's filing. Our office has been contacted by Attorney Zellner's office regarding that exhibit. If you are so inclined, you may refrain from making a payment until all documents have been filed and a new payment advice has been sent your way. So, yeah, let me go back to her original thing and pull up the, $748.75. They wanted me to pay for. They say it's 599 pages at $1.25 a page. So thankfully, Kathleen posted it on her website, and I don't have to try and pay this $750. So, yeah, according to that, I don't know yet. Kathleen hasn't filed it yet. All right, let me go back and scrolling to your things because it's been on for an hour and 38 minutes. It's 12:40 p.m. my time. I will end this in 20 minutes. So Kathy says the prosecution didn't say they were human, but the moment they gave them back to the HF, that made them human remains and contaminated, correct? Right. Yeah. So as soon as they went back, you've broken the chain of custody. So yeah. Rob says Ghostbusters is coming for the bad men. Justin says they gave evidence away, plus it wasn't even her bones. Well, we don't know. It could have been. They just didn't care to look. Because the state doesn't want the gravel pit bones to be Teresa, because then that proves it's not Stephen. So they weren't going to look at it. And his defense didn't do it either at that time. David says miscarriage of justice from start to finish. Yes. Kathy says, hence not allowing Avery to test them ever. Right. You can test them if they, it's not known what the Hallback family did with them, if they were cremated or buried. But no matter what, that's why when you see things in evidence, it's like taped shut. And there has to be initials and a date on the tape showing the tape's not broken. And this is the date and the initials of the last person who had opened this, and that it has to remain in custody. That's why, too, you see that on that ledger that they then kept from Kathleen. So you can see it. And I don't know if it's in the exhibits that she has submitted today, or she submitted yesterday, that she posted on her website today. If you can see where it was Wiegert signed the bones out, and then Karen Hallback signed to receive them. So that is full stop right there. That there's nothing you can do with them anymore. They're out of your control. So this is a huge screw up on the state's part, or a huge cover up. They knew this was the perfect way to get rid of these bones forever. We'll give them to the Hallback family. But it just makes no sense when they're saying the whole time that those bones aren't Teresa's. Why would you give them to the Hallback family? And why did you give them to them? Because now remember, this case was in 2006, and they gave them to the Hallback family in 2011. So it's not like, well, we want to get this to them for the service. They already had whatever service they were doing for Teresa back in, 2006. So why 2011? All right, going back to your comments. Cian says, let's hope Carol Ann gets called as a witness in the new trial. Prosecution would have a very hard time discrediting her if she's an ex-copper. Candace says, Jax, your name for him is tame compared to what I call him. Yeah. Michelle says, go into jury tampering. For people who are new or you don't follow everything, there were two people on Stephen's jury that were affiliated with the Manitowoc County Sheriff's Department. One of which, his name is Carl Warden, I believe, Warden. So you can Google Carl Warden, Manitowoc Sheriff's Department, and you'll see a picture of him in a Manitowoc police car or sheriff's car, because he's a community, not only is he a community service officer, or at that time, for the Manitowoc Sheriff's Department, his son, when you Google pictures of Stephen Avery and you see a picture of him when he's in, when he's in the orange jumpsuit, when he's going to or from court or prison, and he's handcuffed, and there's a female deputy on one side of him and a male deputy on the other escorting him. The male is that Carl Warden's father. So that man was one of the jurors. And he was quite a dick from what I've heard. And from the get-go, his job in there was to make sure the jury said guilty. And people were intimidated by him. And then the other person on the jury was married to somebody who worked for Manitowoc Sheriff's Department. So you had two people that were on that jury. So Stephen was never going to get a fair trial. There was no chance of getting a hung jury, or not a hung jury. I mean, being declared innocent. At best he would get the hung jury, because those two were never gonna say not guilty, because their mission was to be on that jury and to vote guilty. Awesome, isn't it? And I've asked Buting in person when I've talked to him about that, on why were those two people on the jury. And he said because they planted so many people, and you're only allowed X amount of strikes. So, So that's another thing of tampering with the jury pool, that they were putting all these people in the jury pool, that all of them were going to be Manitowoc plants in there. So there was no way not to have somebody on that jury. So infuriating. All right, let me go back to as far as I can go on your guys' stuff. Brianna says, exactly. Why is there no blood in Steven's bedroom? Yeah, well, because apparently, he's just this massive cleaner. With everything. Now, yes, they did try both Stephen and Brendan for completely different scenarios, which is another thing I never get, on how you can try two people for the same crime, but totally different ways somebody was killed. But if you go by what they made Brendan say, cut her throat, stabbed her, cut her hair, and none of that's going to be around that room. You're not going to find her hair somewhere. Holy cow, well, you can't see. I can pull my hair out right now. I shed like crazy. And so you're going to say that you cut her hair and then you don't find anything of her being in there? And even if you didn't cut her hair, I'm sorry, my hair would still be all over that place. Mary says, your credibility isn't being questioned. The prosecution is. I'd keep calling Ken Kratz names, and worse ones at that. Brianna said, why did police sit on Stephen's bed making reports when there was allegedly a rape and stabbing on that bed? Yeah, how about it? Rob says, 1 and 2, someone coming for 1 and 2, someone coming for Kratz. 3 and 4, someone will get Kratz. Michelle asking about jury tampering. Okay, I've answered that already, hopefully. Candace says, if I spent 18 years wrongly convicted of rape and a murder, I would not be freed, then do something stupid like killing some woman I've met a few times before. Stephen just needs someone decent to love him. That's what he craves. Yeah, that's my big hope for Stephen, is once he's freed, he gets to spend some quality time with his parents and he's able to find someone who truly loves him. But that's going to be really difficult because there are so many wannabes that just want to get their hooks into Stephen, or even have their hooks into him right now. So it's it's going to be hard for Stephen to find somebody who truly wants to be with Stephen and is not trying to get the fame or the fortune, which is even funny too. The fortune, you don't walk out of prison and here's your $3 million. He's going to have nothing for years. It's going to take years for him to sue for a wrongful conviction. So, and while you're waiting to go to trial, you can't do interviews and talk shows and books and all that. So all these people wanting to get their hooks into his money, there isn't going to be money for a while. Candace asked me if I talk to Stephen or his family. No, I do not. I used to talk to Stephen, but because I do not support his family ripping off supporters to get money for their own pockets, they got Stephen all mad at me. So I shed a little tear over that. Scott says, is it possible that the reason for the state and county fighting so hard and ignoring new evidence to keep him in prison is because of the money? Think about it. His rape case would have to be paid out. No, that was already done. There's nothing he can do about that one. Now this case, also the Brendan has money for the wrongful conviction, not to mention the Hallbox would also file suit. This would bankrupt the county and possibly the state. Well, I'm sure there's many reasons, but you also have to remember the slippery slope. Because if you're able to prove the prosecutorial misconduct on this, and, so that the district attorneys, the sheriffs, the investigators, all of this did this, Now you got to look at everything else, every other case any of those people have ever touched. What'd they do to the Ricky Hochstetler case? Did they do something in the Carmen Boudwell case? And then all the other ones we haven't heard about. So there's a lot at stake here because everybody is complicit in this. You know, anytime any of these people arrested someone, everything they've touched, it's the poison fruit from the poison tree. So, you know, don't know if anything will ever happen with any of it because, of course, it takes money and then it takes time. You know, none of this stuff moves swiftly, you know. So, but hopefully now that Wisconsin has a new governor and state's attorney, maybe they'll start switching stuff around up there in Wisconsin, and maybe it'll be easier to bust this stuff open. But there is so much here because you know that they just flat out went for Stephen. And a key was planted. A bullet was planted. Stephen's blood was planted. The sweat DNA was planted. Wasn't planted. Actually, the sweat DNA on the latch, somebody searching the cars is the one that transferred that. They never talk about that, but the guy had been searching Stephen's Grand Am and then went to the RAV4 and didn't change his gloves. So he transferred from Stephen's vehicle onto Teresa's. So this sweat DNA that doesn't exist, sweat DNA is not a real thing. Your sweat would carry your skin cells, but there's no DNA in sweat. So that wasn't, I don't think that was an intentional plant, or was it? Because because you've got the whole battery. Then there's that whole battery thing, that there was a different battery in her car, and Kathleen has traced that battery. So, so much here. But, so Kathleen's filing and all the exhibits she has up on her website, and we have the link posted in here. So you can go and see that stuff for yourself. I'll also be hopping into, we have another group that's called MAM Gossip, and that's where we get more in depth into Stephen's case, but we also cover any other case you can imagine. You know, we allow all discussion on all different cases in there. I'll go live over in there, but I'm not going to read the filing again. You know, took an hour and a half to read it. So everybody else is on their own. If you want to read that, but the summary, as I've got 8 minutes left here before I'm going to end this, don't make me do math, 6 minutes. The summary is, again, these bones. They hid these bones from Stephen's lawyers, and it's only through a FOIA that the ledger was found, and that Carol Ann Fitzgerald then sent that Kathleen's way to show that in 2011, Wiegert signed the bones out and Karen Hallback signed to receive them. And these are bones that in court, Sweaty Sweat said, these are not Teresa, and we don't care about these bones. These aren't the bones you're looking for. Don't look over here. Look over here. So Stephen was not given a fair trial on these bones. And this 41-page thing that she filed, because I don't like this about our court system, is that you have to show precedence. You have to show another case to argue your case. And I just find that to be bullshit, because Really? So are you saying nothing original ever happens ever again? So you have to find another case that had the same thing happen that happened in your case for me to be able to think about it? No, you should just look at these facts and determine by these facts. You shouldn't have to go through and write up 41 pages to show you all these different cases where you prosecuted a guy saying it was blood on his underwear in this murder, and he told the jury that it was his blood when in reality you knew it was paint. And now you have to use that in Stephen's case about these bones. You shouldn't have to do things like that. You know, it's just obvious that you're saying these bones are not Teresa. Don't look at these bones. You killed her at your house and burned her at your house. But now, 6 years later, 5 years later, whatever it was, you're going to give the bones to the murdered victim's mother. You're admitting right there that it's her. And then she couldn't have been killed at his house. So who did it? Bobby. We know it was Bobby Dassey with help by Scott Toddick. All right, let me look at what you've said here in the last 3 minutes. Jordan says, my hope for Stephen and Brendan is that they pack up and get out of Manitowoc. Yeah. Janine says, why murder someone with a documentary team following you? Well, they weren't following him at that time, but Scott says, this shall be the largest awarded to Stephen if he gets a lawsuit. I heard someone on TV say it should. He should just own Wisconsin. CN says, Jax, he will see everything you've continued to do to get his case out into the public. We know you've been genuine all the way. Well, thank you, CN. Oliver says, poison tree. Fuck yeah, it all is. Candace says, Jax, in UK, there are people that can check old possible burn site soil, even if burn site was from years ago. Did it here on a murder? Can KZ get that done on possible burn site near quarry in the wooded area? And they can test soil for human bone fragments if burned as seeps into soil, even if from years ago. Candace, I know Kathleen has talked about something like that before. I don't know if she was saying anything about the gravel pit, but I know she was looking at the Dassey Yonda garage, because it's believed that Bobby cut Teresa up in the garage, and that even now you'd be able to find that blood there. But we haven't heard anything on that, so so I don't know. Olivia says, very good point. Every case will have to be looked at. I know I sure as hell would if I was currently incarcerated, if I've been incarcerated at any point, period. I would go, hey, somebody look at my case now. I want to see if they were just pushing their narrative. And I have to go to court in Manitowoc County this week. I have a court date this week, my pre-trial date, because they're coming after me for trespassing, alleged trespassing when I wasn't even there. So we'll see what they do to me. I'll update you all after court. Sherry says, yes, but I thought that's what was passed for Stephen just before he was convicted again, the wrongful conviction. I don't know. Cheryl says, bullet wasn't planted. It was from previous owner firing shots. You're right, Cheryl. You're right. So, but it's still planted because they put Teresa's DNA on there. They used her chapstick and put it on the bullet. But you're right, Cheryl. I forgot that it was Raleigh Johnson, because it was Raleigh Johnson's Marlin rifle that was hanging over Stephen's bed. Because that's something else that they always think that Stephen lived on Avery property. He didn't. He lived on Raleigh Johnson's property. At one time, Alan Avery sold a piece of his land to Raleigh Johnson because Raleigh Johnson wanted to put his trailer there. Jody and Stephen were renting that trailer from Raleigh Johnson. everything in that trailer was Raleigh's, except for their personal belongings. So all the furniture and stuff, dishes, all that was Raleigh's. Jody brought in a bed and a computer desk. Everything else was Raleigh's. So the Marlin rifle that hung above Stephen's bed was Raleigh's. Now, correct, Stephen was a felon due to him running his cousin off the road and pointing the unloaded gun at her. So being a felon, he is not allowed to have a gun ever again. So that was what they first took him in for being a felon, having a firearm. So regardless of what happened with Teresa in the case, he would still be prosecuted and have done time for being a felon and having a weapon on his property. But that gun was not his. He didn't use that gun. That was Raleigh's, but it's his stupidity that it was just hanging up on the wall in there. But Raleigh testified he would go around shooting. And then we saw Kathleen in part 2 firing into the garage so she could see herself. That stuff was wedged in there. But it's still planted because they took Teresa's chapstick. Why are you taking evidence from Teresa's home and bringing it to Stephen's house? That makes no sense in your chain of custody to bring from Teresa's house to Stephen's unless you're going to do something with it. And so they took her chapstick and put that on that shell casing that they threw under an air compressor. That then everything in the garage is all dusty except that casing. All right, we're at 102. I'm already over. Can I post the link to Kathleen? Let me post it. I don't know if anybody's done that already, but you can always go to Kathleen. She's got a whole bunch of stuff posted there. Oh, I see somebody already did. All right. Yep. This is a microphone. This was actually my Christmas gift from my son and his girlfriend for doing this kind of stuff, to use this microphone. And I'm supposed to be getting something made or whatever that's going to then a swing arm thing so I don't have to hold it. Yeah, there was red paint on that bullet too. No, Tom, don't make me do math. Candace, I read your comment about the soil in the UK. Just scrolling real quick. So, all right. Well, I'm just going to not, I've been on here for 2 hours, so I'm going to end this one now and then let my dogs back in, and I'll go live in our group MAM Gossip so we can discuss it a little bit. Oh, shoot. Okay. It's only 1 o'clock here. I have another event tonight I have to go to. So, all right. Bottom line, it's again the bones. So this is Stephen should be let out. And she's also trying to get Judge Flowers off the case since she has been involved in other things. So she's not going to be impartial. So, but that'll probably get turned down. But, you got to try. You throw everything at it. So I will end this one now. And I will go into gossip. Why can't I get my end button down here? Where is it? I don't have end on here. That's weird. I don't have where I can turn this off. It's missing. Let me see what is going on here that I can't end this. Sorry, silence now that I don't have a button where I can end this live. It's gone. I can't end this. So I don't know if that means this whole thing's going to get lost and nobody will be able to read it from here on out because I have no end the live button. That's crazy. Why is that? All right, let me click up here. Nope. Oh, wow. All right. Well, I'll just try and refresh the page and maybe that'll do it. So anyways, I'm out of here one way or another.